So I'm Andy Agathangelo, the founder of the Transparency Task Force. We are a certified social enterprise. That simply means we exist to make an impact rather than to make a profit. And the formal mission statement of the Transparency Task Force is to promote ongoing reform of the financial sector so that it serves society better. And the reason I've decided to effectively dedicate my working life to this cause is because I and our members believe that the financial industry is profoundly important to the well-being of society, to economic stability, and to political stability as well. We mustn't underestimate the importance of a stable economy to give a stable political landscape. In fact, if you think about what's happened since the global financial crisis, you can trace many major geopolitical developments back to the global financial crisis, which in turn you can trace back to malpractice, malfeasance, misconduct, and mis-selling by the banking sector. So this, we believe, is important stuff. Now, whilst we understand the financial industry is profoundly important, we also believe that it has a very high predisposition to misbehave. And that phrase, a high predisposition to misbehave, is a very polite way of saying that given half a chance, the financial sector will rip people off if it can, because it has profit-seeking instincts in the same way that a shark has instincts and sense and of smell and so on to be able to detect blood in water, 10 miles away or whatever the figure is. So we're talking about a sector that is very important, that can and often does allow itself to go horribly wrong. I mentioned the global financial crisis. Let's not forget, folks, that the global financial crisis didn't just cause economic carnage around the world, it also caused social carnage around the world. In fact, I'll put a link into the chat shortly that will take you to some evidence published in a major medical journal. The topic is about depression, and the research shows that over 10,000 people around the world committed suicide as a consequence of the economic consequences of the global financial crisis caused by malpractice, malfeasance, misconduct, and mis-selling in the banks. So this is pretty serious stuff. Today's meeting is probably different to every other of the hundreds and hundreds of meetings that we've run. It is effectively a coaching session, a masterclass with an individual who I know from having interacted so frequently with Paul, which is a pleasure to do over the last few years. I know that Paul Carlier is an absolute right up there in terms of subject matter expertise on the topic of data subject access requests and freedom of information requests. The title of our event, as you know, is how to use data subject access requests and freedom of information requests to get to the truth. One of the things that Paul says time and time again, and it's a pleasure to hear him every time he says it, is that all he's trying to do is to establish truth and fact. All he's trying to do is establish truth and fact. In a short moment, I'll be sharing. I'll be inviting Paul to pick up from where we got to. I'm first of all going to share my screen just to try to kind of prove, if that's the right word, a couple of the points that I've been making already. I'm going to share my screen here. What you're looking at, folks, is a table of data inside Violation Tracker UK. Violation Tracker UK is a database of infringements that the Transparency Task Force put a lot of effort and time into trying to get it established in the UK. We've managed to do that successfully. This particular search you're looking at in the database is a list of the industries in the UK ranked by how much they are being fined. The data goes back to the year 2010. It's a bit small, you might not be able to see it, but the top one is the financial services sector. Over £5,000 million worth of fines. Now, if we had time, I could spend the next hour explaining my view about why the financial services sector should not be anywhere near the top of the list of naughty industries, let alone being the very, very first one. It really should not be like that. And if you click on the word financial services, it takes us to the worst offenders, NatWest, Barclays, Lloyds, etc. And then it shows us the worst offending individual cases. So the very top one, by the way, is Credit Suisse for banking violations in 2021, a fine of £292 million. But then you ask yourself, okay, great big fine, but how big was that fine compared to the violation or the infringement that was going on behind it? How much money did Credit Suisse make perpetrating whatever that act was, that banking violation? Oh, and by the way, who's paying those fines? Of course, the answer is the shareholders of Credit Suisse, the innocent shareholders, savers, investors, pension savers. So where's the logic in finding the innocent victims of the shareholders of the bank, as opposed to going after the individuals responsible for whatever it was that Credit Suisse was doing? And let me show you this as well, because sometimes people try to kind of make out that these banking issues are all a thing of the past. I've just sorted the table according to year. If you double click, it goes to the most recent first. And look what we've got in 2022. Price fixing or anti-competitive practices by MasterCard. Barclays Bank, consumer protection violations. Lloyds Banking Group, consumer protection violations, and so on and so forth. And when you scroll down that list, two things hit you. First of all, my goodness me, not only has this stuff been going on, years and years ago, it's happening in the here and now. This is 2021 data. Before that, you saw 2022 data. But this is also what we would call evidence of recidivism, which is proof that the same organizations are being caught doing the same things over and over again. And all the evidence suggests, ladies and gentlemen, that they see being caught for doing bad things as a cost of doing business, which speaks to a really rotten culture within parts of the financial industry. Now, one of the reasons for explaining all that is because we need you to really understand and grasp just how big the sums of money are that they're being fined. Because those sums of money that they're being fined are a small fraction of the money being made by doing bad things. Now, once upon a time, criminals would be quite comfortable putting on a balaclava, walking into a high street bank with a sawn-off shotgun, threatening murder of innocent people unless they get given the money, and they might walk out that bank with what, 10, 20, 30, 40,000 pounds? Sometimes a lot less. These banks are making millions of pounds doing bad things. There's a Charlie Munger quote. Some of you have heard me mention this before. Charlie Munger, the right-hand man of Warren Buffett. The quotation is, "Show me the incentive and I will show you the outcome." My point is this: the incentives of these banks and other financial institutions to do bad is enormous. You know how much money some of these people earn, literally millions of pounds in bonuses. Literally millions of pounds in bonuses. So ask yourself this: how incentivized are they to cover up the bad that they are doing? You know that phrase, dirty deeds get done in the dark? Would it therefore not be surprising to you, ladies and gentlemen, if these very organizations are doing everything that they can within the law to not reveal what's going on? And by the way, my emphasis of within the law is quite specific. But let me now go one step further. Based upon the evidence I've seen, and by the way, this Zoom meeting is being recorded. It's going to be available to download for our members. I'm happy to go on the record. I've seen enough evidence to genuinely believe that there are organizations who aren't just operating right up until the edge of breaking the law, they're actually going beyond it. They're actually going beyond it. And part of today's event, ladies and gentlemen, is to expose that. And having exposed it, we want as many of you as possible to do what you can to help share the message. So this is a particularly important Transparency Task Force meeting for members about data subject access requests and freedom of information requests. You're very, very fortunate, believe you me, to be hearing from Paul Carlier, a subject matter expert in this area, and frankly, a few others as well. And not only is Paul going to be talking to you about the processes and the procedures and the best practice to get to the truth, on the way, he's also going to share with you some of the discoveries that he's come across. Before we do anything else, folks, could I please invite you to put your hands together and welcome and thank Paul Carlier for what he's about to share with you. Paul's got a lot of ground to cover. He'll be talking through until about maybe 10 to 1, maybe 1 o'clock, maybe a little bit afterwards. Pin your ears back. You're not going to want to miss a word he says. Mr. Carlier, thank you for being such a brilliant ambassador for the TTF in so many ways, on so many levels. Over to you, sir, to share freely what you've learned about this topic. Cheers, Paul.
Okay, I need to explain. There's been some events over the last 24 hours that has turned this presentation into rather more than just what it was going to be. I'm including a case study in this that involves the BBRS, the Business Banking Resolution Service, that some of you may be aware of. And in the last 24 hours, I gave them an opportunity to comment on what I was going to say. And in the last 24 hours, their in-house lawyer has made threats against me, has made allegations against me, all of which are unfounded, and in an attempt to prevent me from making this presentation about them today. I stand by everything that I'm going to say today. And in the course of the lawyer's desperation, he has rather revealed that he revealed an email between him and the ICO that confirms my position and rather further challenges his own representation. So it's going to be slightly different. I was late getting on because I've been desperately trying to tweak the presentation in the last hour or so to include this. So it's going to kind of end, but I'll discuss the freedom of information request issues more verbally as opposed to within the presentation. So I'm going to start the presentation now. Okay, so obviously how to use data subject access requests and freedom of information requests to get to the truth. And this is really important to understand because, you know, data controllers, and I'll come to definitions shortly, you know, your personal information is out there and can be in the possession of a variety of people, bodies, firms, etc. But you have a right to know what they hold about you and the reason for which they're processing it. So And it's important that you exercise these rights, because you need to make sure that they are doing so for the right reasons and that they have a legitimate reason to hold the information in the first place. Now, you have to be careful, because there's an exemption that if there's litigation in process, or then you don't have these rights. Instead, the disclosure of information will then be part of the litigation in which involves the disclosure process. So it's important to us to use these to establish truth and facts. And I always do this when, if I've had a complaint with a firm or something, or any party, and it's reached a conclusion, submit a DSAR. Let's see what's there and what what they have. So it's important that when you make it, no litigation, it is establishing or exercising your rights to obtain the information they have. Again, and I always make this statement: I never make an allegation or complaint unless I believe that I'm right, and I never make an allegation or complaint unless I believe I have the evidence to demonstrate or prove it. That applies to this presentation, and if I'm expressing an opinion or a conclusion, then I will establish that and the grounds and/or evidence for drawing that conclusion. Quote from Tom Clancy, and it is so true: the control of information is something that elite always does, particularly in a despotic form of government. Information knowledge is power. If you can control information, you can control people. And a lot of the things I'm going to be referring to today are in reference to, let's just say, non-compliant and or unlawful interpretation or conduct by certain data controllers. Now, and it's important to establish that this tends to happen if that data controller has something to hide. If it's a genuine data controller with no problems, then you will get a compliant response to either your DSAR or your Freedom of Information request. So first of all, what is a DSAR? Quite simply, it's a data subject access request, and it's defined here. And what you're going to see is they're quite text-heavy slides. The reason for this is that this obviously will be videoed, and this will give you a resource to come back to. You can watch the video back, you can pause it and stop it and take notes or extract what you need to from it. So, some of the slides, I'm not big on imagery and everything else. There'll be text, rather text heavy, but they will be very relevant and hopefully provide an ongoing resource. So this is what the ICO define it as: the right of access that gives you, the individual, right to obtain a copy of your personal data, as well as other supplementary information. And as it says, it helps individuals to understand how and why they are using the data, and to check if they're doing so lawfully. And it is a right afforded by UK GDPR, the General Data Protection Regulation that replaced or updated the pre-existing Data Protection Act. You will sometimes find them referred to as a SAR, as a subject access request. I always prefer DSAR, because SAR is a term used to describe another issue called a suspicious activity report relating to money laundering issues. So I always like to use DSAR. It distinguishes it and establishes exactly what it is. So a data controller, quite simply, a data controller is the natural legal person, public authority, agency or other body, and this includes your bank, this includes your energy provider, even gambling. If you've got a betting account, it includes them as well. So public authority, agency or other body which alone or jointly determines the purposes and means of the processing of your personal data. The data subject, quite simply, is you. And it's important to understand that only you, the individual, has the right to make a data subject access request. And this is one of the issues that I've raised with various parliamentary committees, because why are SMEs and other businesses not given that same power or that same right? I know sole traders that had IRHP issues received far more information and far different outcomes than regular SMEs, because as a sole trader, you were regarded as an individual and therefore you had rights to access all this information. And some of the information some of these people got is astonishing. So, but you need to be important. It only applies to you, the individual. If you're a director of a company that banks with, say, Barclays or Lloyds, still submit a DSAR, because if you personally are mentioned, they still have to disclose that. So, but you don't have access to the company's information. So a DSAR is one of the least understood rights individuals have, and it's still astonishing me today that so few people understand what it is the rights that it gives you and also the power it gives you as well. Because if you make a data controller aware that you know you have this right, I guarantee you it makes them think twice when dealing with you in the future. So now but it's often misunderstood what constitutes personal information. With a lot of times it'll be, oh, just something that mentions you by name. No, it doesn't. Okay, and there's various interpretations of it, and most data controllers, if they've got something to hide, will seek to disclose information of a certain type in a certain way, which is a clear misinterpretation or a dishonest interpretation of what the law is. Deloitte, for example, in one DSAR response to an individual, sought to literally provide a one-page list of all the personal, so the person's name, person's address, person's email, person's phone number, say, there you go, that's it. Astonishing attempt to withhold information. And I'll come to that. So, but this is part of the playbook. If someone's got anything to hide, you'll see that when you get your initial DSAR response. So, and there's a playbook that, sharing my own experiences and that of many others, which we are beginning to formulate, and I'm going to be discussing later on. So these following slides these are taken from my template DSAR, which is put together with myself and a data specialist barrister, and I've put a link in the chat where you can download a copy of this. But it's important that everyone understands this is what constitutes your personal data. So any information about me, whether direct or implied, and this is really important, because if there's an email that says, oh, he said this, and if it's quite clear that that he is me or that she is you, they have to disclose that, and they have to disclose everything. And they have to disclose any opinion of you, whether direct or implied, i.e., again, he's this or he's that, they still have to disclose all of that. And any information demonstrates or implies any intention of the data controller in respect to you, how they propose to treat you, and any actions that they are considering taking in respect to you, right? And this must include any information that contributes to the formation of that opinion. So if people are discussing you via a thread of emails, and it's all about you and what they propose to do, or what they, or the forming of an opinion about you, they have to disclose it all. And the only thing that they can redact is the personal information of another third party. So if it says in there that Joe Bloggs said that about Mr. Carlier, they can redact the name Joe Bloggs, but the rest of it has to be disclosed. But that is something most data controllers will seek not to apply to a DSAR response, and presume that you will not understand that you're entitled to all of this information. And importantly, as I mentioned before, it applies to complaint processes. And even in my case, in my own case against Lloyds, when I did the DSAR, they have to give you all the emails that you're between colleagues discussing you as well, which is quite eye-opening when you actually get this kind of stuff. This is specific guidance. This was produced by a data specialist barrister, and it actually quotes ICO guidance that explains this. So it may be personal data because its content is obviously about an individual. And again, if it says he, she, that's disclosable. Now, time and time again, I find data controllers, they'll disclose a line that has your name in it, redact the rest of it, but the rest of it is still about you. It's still relevant to that. You're relevant to you, relevant to something about you, and should always be disclosed. So again, this is not my opinion. This is expressed here by the ICO. This is from the template, and I always include this because you want to make it clear, because you don't want to give them the opportunity to withhold stuff. I know you might try, but here's what you need to disclose. And as you can see, it's all communications, notes and statements made internally between them and their employees in any media or format regarding any business, and also any communication with third parties about you. It all applies. So that DSAR template will give you a perfect definition of all the criteria of information that you're entitled to. The bottom one is a delete if applicable, if it might be your bank and you want to, or any other partner you've had and you've got a statement of account with. Now, this is really important, because this is one of the ways in which a data controller will seek to withhold information. Now, another obligation they have to demonstrate to you the purpose for which that information is being held, right? And that can only be achieved by way of provision of all information in its native format, appropriately redacted only to conceal any information that might be the personal information of third parties. Now, why is this important? Because like I mentioned earlier with the Deloitte's example, a list of just the actual personal information, right? Well, that doesn't demonstrate the purpose. That, for all we know, that could have been a dishonest sharing of in an email that was dishonestly sharing my personal information with a third party they had no right to share it with. So just that list doesn't tell me the reason for which they're processing it. And this will force them to disclose all the documents in their original format, only with the personal information of other third parties redacted from it. It's really important. So, right, the unlawful playbook. I need to say that this is only, again, if the data controller is acting dishonestly or not, or acting unlawfully in respect to your rights, these are the types of things you see. But we are seeing this on an industrial scale. Just to give you an idea, this year alone, I think I've got 12 complaints with the ICO, and of those that have been processed, 8 have been upheld. And all on the basis of the same practices time and again. And I've helped others with similar complaints. And again, all of them being upheld and all of them identifying this playbook. So one of the examples I'm going to be using is the Business Banking Resolution Service, or BBRS. As I say, in the last 24 hours, there's been an escalation of communications and threats and all sorts, but I'm standing by my position and I'll explain to you and show you the evidence as to why later on. But the fact that they've made threats is an absolute disturbing. This is an organisation. It's supposed to be independent and provide objective review and a dispute resolution service for SMEs across the UK. It's been much touted, much vaunted, and their behaviour in respect to this has been nothing short of shocking. And where I keep, okay, I've got this, that they keep just compounding it further. And so it's escalating to what it's now become. But make no mistake, the BBS are far from alone, okay? And my own personal experience, I've got Deloitte, Lloyds, HSBC, Barclays, UBS, the FCA, Metropolitan Police, Kent Police, and even the Serious Fraud Office, all adopting exactly the measures that I'm going to be explaining next. I mean, the SFO, astonishing, they refused to disclose the notes taken at my interview with them when I was reporting serious misconduct in FX in 2015. Now, it was notes in respect to my personal testimony. And there's a reason why they didn't want to disclose it, because in that, I highlighted some significant and serious issues with senior management at UBS. And at the time that I was making these reports, Tom Hayes' trial was ongoing. And one of Tom's defences was that UBS senior management was aware of everything he was doing and, entirely approving of it. And here I was with information inadvertently that appeared to corroborate what Tom was saying. And the SFO are desperately trying to seek to prevent from disclosing those notes of my testimony to me, and that's subject to another complaint. So this isn't me just highlighting the BBRS. This is what you're going to see is stuff that we see from all data controllers. So playbook number 1, and again, this is all based on significant intelligence internal records I have. When receiving a DSAR request, large firms or bodies will typically collate all the information into 2 files. One called the seen file and one called the not seen file. Fairly self-explanatory, but basically the seen file is documents that you, the subject, will have seen, i.e. emails to and from you, letters to and from you, that kind of thing. But for obvious reasons, the not seen file is the file that will likely be of most interest to you and reveal whether or not they're acting lawfully in respect to you and processing your data lawfully. However, it will also be the file that contains any information that the data controller might not want you to see. But there's no caveat in the UK GDPR that says that you have to disclose this information unless you don't want to, or unless it might embarrass you, or unless it is going to expose something that you have done that is unlawful, dishonest, or otherwise. So now, after the data controller has collated the data as described, the typical response to your DSAR will be, the data controller sends you a list of personal information, like the Deloitte's example I used, or B, the data controller sends you all or part of just the scene file, right? Now, I received a DSAR response from Lloyds last year, 3,000 documents or 3,000 pages, and every one of them was an email between me and Lloyds, and obviously the repeated email exchanges. So it was padded out. There was not one document that I had not seen. Now, an important thing when you're identifying if the disclosure response is lawful is that every incoming email from you and from me has to have generated some kind of internal response. It might have been a note, it might have been an email to somebody else, but it's very unlikely, especially for regulated firms or businesses and who have obligations under law, that they would have just ignored it entirely. So if there is nothing that you have not seen, the chances are this is unlawful and they are withholding your personal information. So, or the data controller might actually send you some documents from the not seen file, but that will generally be a token. So moving on to the next one. So if the data controller does produce a DSAR response as described, you have the right to challenge it. If you, as I say, if every document that they send you is one that you've already seen, it cannot be lawful or compliant, because if this is a DSAR from a bank, what are you saying? That the bank, there was nothing in between your email to them and their email back to you later. There was no discussion, no note generated, nothing. It's so inconceivable that it has to be impossible, and therefore you challenge it. Now, when you make the challenge on that basis, the data controller will typically either make representations claiming that what they've disclosed to you is all of your personal information they have in file and that's it, and stand by their original disclosure, or provide you with the full documents from the scene file if they haven't already done so, or provide you a token few documents from the not seen file if they previously have only provided you with documents from the scene file. However, the token few documents will likely be far from the sum total that exists, will likely be overly and unlawfully redacted, and will likely be the not seen documents that are the most innocent within the not seen file, and they will, will withhold the remainder. So if the data controller has produced a response to DSAR as described and a response to your challenge as described, or that you are not satisfied with, you have the right to escalate your complaint to the Information Commissioner's Office, the ICO. If you escalate your complaint to the ICO and they uphold your complaint, deeming it non-compliant, unlawful, because it's non-compliant with law, it's therefore unlawful, which they are likely to do if the circumstances I described exist. And these are the circumstances for which every complaint I've escalated has been upheld, and the same with others. The ICO will likely order the data controller to engage with you and or provide a compliant, lawful response. However, again, in my experience, the data controller will then typically not actually engage with you, but claim they are working to make their response compliant or lawful, and then eventually either B, disclose some token few documents from the not seen file, if they had not already done this in response to your complaint to them about the DSAR response in the first place, or they will provide a full and compliant and therefore lawful response that includes all of your personal information. However, this rarely happens, and in fact, in my case, I think it's only happened once, and that took a year to resolve. So this is the case study I was talking about, the BBRS. So 10th of February 2022, the BBRS acknowledge my email and my receipt of my DSAR, and if you look at this, I can confirm that in line with our data privacy policy that your DSAR would include any data held by both the BBRS and CEDA. CEDA is their partner, which is a dispute resolution firm, one of the most highly recognised in the UK, apparently. So again, your BBRS, CEDA, two institutions that must know the UK data laws inside out, and therefore there should be no room for any kind of error here. So 10th of February, they say that they will revert, and they have 1 month in which to respond. So on the 19th of February, and this is really important, okay, they are well within the time frame, okay, and this will become apparent as to why I'm saying this later on. They are well within the 1 month period for response. So the BBRS confirm, please find attached our response to your subject access request. So I open it up, and it's this. Basically, this is a 2 and a bit page document, which is the Q&A sheet that they sent me some months after a round table event that they held in November 2020, an event where they said that they would answer every question put to the round table, the BBRS at the round table, before or during it. So I sent all these questions in, and eventually I had to chase them. This is the response I got. But this is what they purported to represent the sum total of the personal information they held. Well, hang on. How do you produce answers to my questions without any internal discussion as for those questions? It's not possible. So this clearly cannot be the sum total of everything that they have. So I wrote back and I started it with, is this some kind of joke? Okay, so and challenged the BBI, so they were purporting that this to be the sum total of the personal information. I'm going to jump on to the next one here, because here I advised them of the opinion of a data specialist barrister that I saw, and as you can see here, they confirm as a controller their employees or officers misapplied the GDPR, okay, and wrongly withheld personal data. And they also considered their unlawful withholding of personal data may constitute an offence under the DPA and the Fraud Act 2006. And again, quotes the ICO guidance that is specific to this. So I include this in my challenge to the BBRS. But here I summarise 3 broad issues that prove that that cannot be the sum total. One of them, the act of blocking me on social media. I was blocked on Twitter the very instant that the BBRS Twitter page went live. Therefore, there must be internal notes, documents, communications, etc. relevant to this, and it demonstrates exactly how and why the BBRS conceived and then executed this action against me personally. Someone somewhere must have told them, block Paul Carlier. There must be an internal record of that note or communication as to that, and probably more than one, because it would surely have been subject to some discussion. So, and there's nothing in there, obviously. So my blog article was published and the BBRS are aware of. Emails were sent to me in response to the emails I sent to the BBRS on repeated occasions, to which my blog articles were attached. Okay, now I eventually get a response from the BBRS, but in that DSAR response, there's nothing about that indicates any internal note or communication which must have taken place in response to my incoming email and the blog that I presented with them for comment. So all of which constitutes my personal information. And lastly, the recruitment process for chair of the SME liaison panel and other roles that I applied for. I applied for several roles with BBRS and got knocked back on all of them. And I point out there will have been internal and likely external discussion, notes, communications, etc. in respect to each of these applications. All of that constitutes my personal information. So this is a summary of the response I get back from the BBRS, and it's great. They acknowledge that the BBRS takes its compliance with the GDPR and data protection legislation very seriously, compliance and accountable. They say, for our retention policy specifically states that we must remove all recruitment data after 6 months. There's 2 problems with this, and one you'll see shortly. One of which, but the other one is the fact that when they were knocking me back, they promised to keep my information on file for potential future roles. So are they lying here when saying that they destroyed all these records after 6 months, or were they lying to me when they said they would keep my records on file for potential future roles? So he says here, we explained that we have not provided copies of the email exchanges that you had directly with us, as these are already in your possession. However, if helpful, we can provide copies. He misinterprets, deliberately, I presume, what I've asked for. I've asked for the emails between my incoming email and the email that comes back to me. They have to exist. He deliberately avoids that issue, right? But he's expressly implying that there is no such, none of these documents exist. And he says, with regards to Twitter, we have third-party agencies managing certain aspects of our external communication. Since go live, these agencies have changed. I would like to assure you that outside of the correspondence we have mentioned to you already, we do not hold any further personally identifiable data on you. So he's confirming there is nothing else there. No internal docs, no internal communications, no internal notes, nothing. And with respect to this, and he says, apart from providing a duplicate copy of the email exchanges that you've had with us, we will no longer be able to assist you. Now, under their privacy policy, and I'll come to this, I now make a much more forensic dissection. I'm going to skip through this But I'm going to include it all here so that you can see everything that I contested. So, and I point out here, well, where are the internal emails? All the notes and that must have taken place or been generated in response to my incoming email, and that prompted the eventual response to me. There has to be some kind of internal issue, and they've got to propose it, because they have to demonstrate to me the purpose for it. But bear in mind, they swore blind, none of that, they had none of this information. So, I've said here as well that there are communication with other third parties. He explains that he doesn't actually deny having the missing documents, but only offers to disclose the emails between us. I refer to the act of blocking me on Twitter, and his response, what the hell is that? It's an embarrassing response. And I then go on to quote from their own privacy policy, which states on their website who we may share your personal information with. It gives a list. It does not say third-party firms for the purpose of blocking you on social media. And don't forget, if they're communicating to a third party, as they confirm they have, well, where's the communication? The other thing is, they're telling you to block you, that's an adverse communication about you. That implies that you clearly must have done something wrong for them to be wanting to block you on social media. So that is creating potential reputational damage to you in the eyes of that third party. So I then go on to basically point out all the obligations that they have and request that they provide all this information to me and without further delay. They stood by their positions and maintained that they had nothing of that personal information that I've identified that I said must exist. So I escalate the complaint to the ICO, the Information Commissioner's Office. Now, importantly, as you saw in my issues, I never once mentioned that, there was a time issue, i.e. that they didn't disclose information in time, because they did. It was well within time, and I never once mentioned it. So in my complaint to the ICO, I don't opine on a time-related issue because there wasn't one. But I do make it very clear to them all of those other issues that prove that this cannot be a lawful and compliant response. And as you can see here, the outcome of your complaint, we have considered the issues that you raised with us, and our decision is that there is more work for the organisation to do. They upheld my complaint on those issues. And I got a copy of the letter that they sent to the BBRS demanding that they engage with me and rectify those issues. So, and here I summarise that. Now, within a month, I get a second DSAR response from the BBRS. Now, bear in mind, everything that they swore blind in respect to my challenges in respect to the first DSAR response, right? So the pages I'm going to show you are just a selection from the second DSAR response. My CV. Apparently, previously they'd said that they had destroyed all information relevant to me in terms of the recruitment process. Well, clearly not true. But token response, because if my CV exists, then so must all the notes about my candidacy for those roles. They must also still exist, because this proves that they kept my details on file for potential future roles, as they said, which must mean all the notes relevant to my CV and to me must still be on the system. They didn't disclose them. Again, it's a token disclosure. These are just a selection of internal emails that they had to disclose in the second DSAR response, all of which are in response to incoming emails from me. So, now again, token response, because as you can see, they're forwarding emails or sending emails to each other. Clearly, you would expect there to be a response. No response is disclosed. So either the BBRS send emails to each other and no one ever replies to them, or this is just a token disclosure of emails and not the full extent of the personal information that I'm entitled to. Now, again, a couple more here. And again, all of them are standalones. There's literally no response to any of them. So, and it's inconceivable that there can be no such response. This one is really interesting because, as you can see, this one it says quickly flagging that the complainant below, me, has posted the correspondence as a new blog. It has received limited pickup on Twitter, 14 retweets, 14 likes, but we're keeping an eye on it to see if any journalists or MPs engage. Right, So they're not responding to me because they don't want to, because I've raised some very serious concerns about conflicts of interest, but they're going to watch it just in case somebody else, if an MP or journalist picks it up, then they're going to have to respond to it. So they are literally monitoring me and my tweets, having blocked me on social media. There's another issue that comes to light in this DSAR response where they produce a separate document that mentions a firm called de Havilland. And it talks about an incoming correspondence from de Havilland, and it's de Havilland Information Services. And when I did a DSAR to de Havilland, lo and behold, they provide basically copies to the BBRS of any tweet that any MP or parliamentarian engaged with of mine. And they provided it all to the BBRS. And in response, the BBRS has sought to claim that, no, it's for political engagement. You know, that's the only reason we invoke the services of de Havilland. So they're only monitoring the tweets and replies by MPs. However, this confirms something altogether different. It says, you know, it received limited pickup, and it effectively says that no MPs or journalists have yet engaged. Well, if you're only telling de Havilland to monitor and conduct surveillance of MPs, well, how did you come across this one then? So again, there's a whole other issue that I haven't really got time to go into now. But all of these confirm that the emails that I said had to exist within that first DSAR response, and these internal emails, they swore blind they didn't exist. Clearly they do. But clearly, again, this is still just a token disclosure. And this is what they often do as well, data controllers, is they'll give you instead of the document, they'll give you an appendix which quotes from a document, but they give a reason why they shouldn't disclose it. Now, on this one, it references an email including the name of me. Now, just disclose it, but redact everything else. It doesn't matter. I mean, if it's an email, just redact it. So I'm certain that there is information in there that should have been disclosed and wasn't. And here's an email reference to this confirms that a BBRS internal email exists, attaching an email from me to Portland PR Communications, which was the PR firm engaged by BBRS. And it includes a statement referring to me, and it says he's factually wrong on a number of bases. Well, okay, what basis am I wrong on? But the fact is that what they're responding to or referring to has to be disclosed to me because it's my personal information. Now, this is another thing that we see time and time again. When they're doing redacted or partial disclosure of documents, they'll pick stuff that makes the data subject appear wrong or appear adverse. And often it's taken out of context. And it's like here, they're trying to say, well, I'm factually wrong. But what am I wrong about? I know I'm not wrong about the subject material that I've raised with BBRS, because I don't raise it unless I've got the evidence to prove it. So, but they haven't disclosed to me what that is referring to. They're just trying to imply that I'm wrong about something. Well, you have to disclose the full picture. So I'll move on to this. Now, this is really important. The second DSAR response that I got proves that the first DSAR response was non-compliant with UK law and therefore unlawful, and also proves that every representation that the BBRS made when denying my complaints in respect to the first DSAR response were false and dishonest. So now, to be clear, my surname, Carlier, is fairly unique, right? If I was Smith, Brown, or something more common, then yes, it's quite likely they would not have uncovered all of my personal information. But all of this stuff is electronically stored, and we use e-discovery software all the time, and it is incredibly powerful and impressive. If you type Carlier into their e-tools or their discovery system, it will produce every document where I'm mentioned, and it will therefore generally include any related document where he or everything else has been mentioned. So they should have, there's no way they couldn't have found any of these emails because I'm named in them. It's just not possible. And we're talking about BBRS, an organisation that puts itself up on a pedestal as independent and objective, has already acknowledged to me that they understand GDPR inside out and they know they have to be compliant with it and accountable to it. And they also work with CEDA, apparently the foremost dispute resolution service in the UK. They're funded by UK finance, and their lawyers are Osborne Clarke, who put themselves up on data protection pedestals as well. So it's impossible that they could have missed the personal information that they disclosed in the second one. I mean, I couldn't have been more specific when I challenged them that this must exist, and they swore blind it didn't. The second DSAR response includes several of those emails that they swore didn't exist. And I do not accept it was incompetence on their behalf that they weren't including the first one. In my opinion, it was absolutely dishonest, because it's impossible they would not have found that information. So I made these allegations and representations to the BBRS and the CEO, Mark Grimshaw. The person that had made the representations to me in response to the first DSAR response that they provided sends me this in response. Now, I've made allegations, all of which is supported by the evidence before me. So, but this person clearly is the one that made false representation. So yeah, perhaps it's unsurprising that he would write this, but did he write it with Grimshaw's blessing or other members of the board? I don't know. However, he wrote this, and in it he says that allegation, you have made a number of unfounded and defamatory allegations concerning the Business Banking Resolution Service, members of its management team, and actions taken by BBRS in response to your data subject access request dated 18th of Jan. So he confirms it's in respect to the first DSAR response. So your allegations are denied in their entirety, and all of the BBS rights are reserved concerning the commencement of legal action in response to the defamatory statements you made. Well, first of all, I can say whatever I want as long as it's true, and when I've got evidence to prove it. And all the evidence I have proves that the first DSAR response was entirely unlawful and dishonest. And those were the allegations I made to the BBRS and the board. So, and this is where it's got quite heavy-handed in the last 24 hours. My representations are not false and they're not defamatory, and all of it proven by the documentary record. So I challenged them, the BBRS, accused them of making allegations they knew to be false and threats of action that they knew they had no grounds whatsoever to make, and certainly know they had no grounds to carry out. Now, that's an offence under all kinds of laws, including the abuse of process in civil procedure rules. In other words, it's to stop firms sending bogus threats of actions to pensioners or vulnerable people, knowing full well they have no grounds to do it, but in the hope that these vulnerable pensioners will panic and pay the monies being demanded by menaces. So you cannot make a threat of action that you know you have no right to make, and certainly have no right to carry out. And that's been my pushback with them, that they have sought to engineer and contrive positions that they know don't exist, so as to generate leverage with which to make these threats. So anyway, this morning, the BBRS doubled down with further threats of the same nature, and in their desperation to enforce these threats, included email correspondence they had with the ICO that proves they are ignoring everything specific to the first DSAR response, and instead seeking to wrongly apply my allegations to the second DSAR response. And furthermore, within those emails is one from the BBRS to the ICO containing this. And he says, this is BBRS counsel, I interpret this to mean that whilst there is no specific criticism of the contents of our second response of 10th of August, the information which was provided in that response should have been provided earlier. He acknowledges that they should have provided that information in the first DSAR response, right? The first DSAR response, they lied about and made representations to the effect that they had none of that information. Here he is admitting it. And that was Jeremy Bennett, BBRS counsel. In the same, this is in an email exchange where he's making further threats that the allegations I'm making are false and defamatory. They're not. And I've said to him, okay, bring it on, take the action against me. And this is why this has all been a little bit delayed this morning. But you can't make threats of action on the basis of something being false and defamatory when it's all there before you in the documentary record. So I apologize if I've gone on quite some time about the BBRS, but as you can imagine, over the last few weeks, this has become much more than a case study, but an astonishing example from an organisation that's supposed to be above and beyond reproach and be independent and objective, that is quite astonishing. They have literally, made threats that they know they have no right to make. And we see this time and time again, though. And I've now challenged the ICO to that they have, because I made complaints about the second DSAR response, claiming it was just the token response. The ICO said, oh, that response was non-compliant, but due to resources, we're not going to investigate further. Well, that has clearly just emboldened the BBRS to come at me and make these threats of action they know they have no grounds to take, which makes them malicious communications. And I've challenged the ICO. I said, well, you now have to take action. You can clearly see that your lack of action, which you've communicated to them, has emboldened them to make these threats. So the ICO have been very good at upholding complaints this year, but as Andy said before, unless there's a deterrent, it's just a cost of doing business. This is a little slap on the wrist. This is an organisation that should be held to an even higher standard, and it has breached any kind of standard of any kind, and it needs to be investigated. As mentioned as well, and I haven't got slides on this, but the FCA, the ICO upheld a complaint of mine against the FCA earlier this year, and ordered the FCA to engage with me and to remedy the issues that I raised. Now, in June of this year, I got a DSAR response from the Complaint Commissioner, and because the Complaint Commission 2018 had reviewed a complaint that I escalated to them that the FCA response the FCA had produced that I said was dishonest and inconsistent with the records. Now, lo and behold, in this, I got about 600 internal FCA documents, 200 of which I'd never seen before. But all of them were being disclosed because they constituted my personal information. All of them dated 2015, 2016, and should have been disclosed to me in February 2017. So I've obviously included that in my complaint. The FCA, having been ordered to engage with me and remedy the issues, wrote back to me and said, because one of my complaints was that the person that produced the December 2016 complaint response to me was also involved in the processing of my DSAR request that I'd submitted in October 16 after the FCA had been investigating my complaint for a year. Now, the FCA wrote back and said unequivocally, we can confirm that this person had no involvement whatsoever in the processing of your DSAR. Unfortunately for the FCA, part of the 200 documents that were concealed from me that I've now got is an internal memo that this person authored confirming that they were also processing my DSAR response, that they were reviewing all the documents and information and were collating it to comply with my response. However, the commonality with all the 200 documents I now have, all internal FCA documents, is that they to some extent or entirely challenge the 5 elements of her complaint response where she denied every element of my complaint response or every element of my complaint. So this person was clearly in a position to cherry pick the disclosure that they would provide in response to my DSAR and clearly withheld the information that would challenge or expose those conclusions for the dishonest positions and conclusions that they were. So that complaint is, I've now gone back to the ICO with the evidence to prove that that was a false representation made by the FCA, having been ordered by the ICO to engage with me and remedy the issues. How does that lying to me doesn't remedy the issues? And this is the FCA. This is your regulator of financial services who must be above and beyond reproach. So, but there's a whole other number of issues. And as I say, it's not just the BBRS, this is a widespread thing. And this is what happens when you know your rights, you exercise your rights properly, and that data controller clearly does not want you to see that which you're entitled to see. And sadly, when that happens, or when they start digging holes or trying to circumvent the law, this is what happens. They just dig deeper and deeper hole, and we need the ICO to step up to the plate here and take the appropriate action, because unless there's a deterrent, it's just a slap on the wrist or a letter saying, no, you're a little bit naughty there, is not going to deter them. In fact, as you can see from the BBRS, it emboldens them. I said earlier I was going to move on to freedom of information requests, and I will do. They're much more simple to explain. The likes of the
Paul, I have a
FCA,
suggestion. Paul,
Yep.
Let me come in if I may. Thank you. I have a suggestion. I want to give you a bit of a mental rest, because it's amazing content, not just the actual substance, but the delivery and the context in which you're sharing what has been happening, particularly over the last couple of days. It really is incredible, Paul. You're such an asset to the cause. We must never ever underestimate just how valuable an asset you are to the bigger cause here. Folks, I know that you want to do this, so please do it with me. Please, before we go on, and Paul will be talking about freedom of information requests in a minute. Before we go on, can we please just take an opportunity to show our appreciation to Paul for what he's covered already? Thank you very, very, very much indeed. Thank you. And I propose what we do, Paul, is we have a bit of a chit chat about DSARs, before going on to freedom of information requests. And if you may, I want to share my somebody's written Sashi's written caps loudly in the chat. That's really sweet. I want to share my screen to show you something I think you've already seen before, Paul. It's the stuff I got back from de Havilland. So let me just share my screen and I'll try to show it. So Paul, basically, I'll explain in general terms what this is, and I'd like you, if you may, just to kind of elaborate on it if you'd like to. So Paul very kindly gave some of us a bit of a sort of template to use to send to this organisation called de Havilland if we thought they might hold some information on us. Now, bear in mind that BBRS, the company employing de Havilland, is about the Business Banking Resolution Service, and I personally am not and never have been a victim of interest rate hedging product mis-selling. So I should not, to my mind anyway, I'm nothing to do with BBRS personally. I'm just nothing to do with BBRS at all. But I thought I'll send one in anyway. I genuinely wasn't expecting to get anything back. But what you've got here, folks, I'll try to make this a bit bigger. You've got what amounts to, and I'm actually a bit uncomfortable using the word because it makes me feel like I'm some kind of conspiracy theorist nut job, but I don't think I actually am. But it actually makes me uncomfortable using the word. But isn't this what they call surveillance? Isn't this what they call surveillance? Because what you're looking at, folks, is records relating to social media exchanges, dialogue, communication, if you like, conversation, if you like, between me and various people on Twitter. Baroness Bennett of Manor Castle, Peter Grant, MP, Stuart MacDonald, another MP, Martin Doherty Hughes, an MP with the SNP, Peter Grant again, Kevin Holland-Rake, Dame Margaret Hodge, Emma Hardy, a Labour MP, Kevin Holland-Rake, the Fair Business Banking APPG. So this is between me and an APPG, an all-party parliamentary group. Stephen Timms, or I should now say Sir Stephen Timms, Michelle Thompson, Alison Thulis. These are all MPs. Angela Eagle, Dame Angela Eagle, it should say, I think. Nick Smith, Lord Tyler, Baroness Ludford, and it just goes on. I mean, you can see the names yourselves. Seema Malhotra, Bob Blackman. So I looked at this, I thought, hold on. Is there somebody working from de Havilland who is literally recording my social media interactions, even though I'm not an RHP victim, even though I'm a campaigner for transparency? And it kind of freaked me out a little bit. Forgive me using old-fashioned language here. Paul, could you explain what's going on there, and why are they doing that, and have they got the right to do it? That's the question.
It is a really good question, and I only got the heads up that de Havilland had any involvement or any of my personal information through the second DSAR response, where they confirmed that there was an incoming email from de Havilland Information Services, and it had reference to one of my tweets. So one of my tweets I point out. So I thought, well, okay, screw it. I'll submit a DSAR to de Havilland then and see what they've got. And there's like 40 tweets of mine that had been engaged with by MPs or retweeted by MPs. Now, that is, so they only disclosed one. Okay, so they didn't disclose all of them. Now, the important thing to say that they have sought to claim that, because of it's for political engagement purposes only, we just want to see what MPs are saying. No, because the internal email that I've got, I showed you earlier, says that if any journalists or MPs engage with it, then we'll, So they're clearly conducting surveillance of my stuff before there's any engagement, as well as when there is engagement. Now, on the de Havilland website, it coaches their customers, and they're not just providing it, they are selling this information. And yes, it's stuff that you've put in the public domain, but they are collating it as per the requirements of their clients and selling that to them. Now, de Havilland's quote on their website, under new data laws, they coach them how to, you must request information from us only for political engagement purposes and legitimate purpose, nothing else. Otherwise, we can't disclose it to you, or you would have to register and we would be forced to disclose to the subject who we were selling their information to. So they coached people how to, the only way that we can provide it to you or sell it to you is if it's for this purpose. Well, it's clearly for not just for that purpose. It's, you know, and if you have to coach people in that respect, then you are, it's almost like wink, wink, nudge, nudge, you know, just make sure you don't say the real reason you want it. And clearly what the BBRS has said in terms of political engagement, and obviously there's political and public interest, isn't strictly true, because they reference a tweet of mine in that internal email that had no engagement with an MP or journalist, but we're watching it just in case there is. Now, but I had no idea about de Havilland. As Andy said, it makes you, you know, okay, you've put it out there, but it makes you uncomfortable to know that someone is being paid to share that. And when I said to de Havilland, I want a list of all the people that you've sold my information to, and they refused, citing that exemption that they coach people to make. So I have no way of knowing how many people they have sold my personal information to. And apparently de Havillands are insisting they don't have to disclose to me.
Well, I've got an idea. Should we try and, maybe we should ask some of the MPs who've been surveilled, if that's the right word. Maybe we should ask them if they'd like be happy to, like, maybe ask a question in the House. You know, what's the what's the word I'm trying to find here? What is the social purpose case for this kind of surveillance by a body that was supposedly set up to help victims of bank mis-selling get compensation? Maybe we should do that, Paul. Maybe we can work together and knock it.
And also, like, I think it would be, I want to know, and I'm going to be taking it further, I want to know who else they've sold my information to.
Yeah. Yeah.
You know, have they sold it to Lloyd's or anybody else? I mean, the FCA, I've got evidence that the FCA is getting large swatches of my social media. Now, is that coming from de Havillands as well? Yeah. You know, it's there is just a discomfort there. And I know that, yes, you're putting your information out there in the public domain, and I've got no problem with that. But if you want to follow, if you want to see my stuff, follow me. You know, BBRS don't follow me, they block me. And yet here they are clearly monitoring, you know, my social media, and clearly concerned about what I'm saying, but seeking, okay, we'll just ignore him unless an MP or journalist engages with me. So it's a bit, and it's like the Tom Clancy quote before that I used, you know, information is king. I mean, there's a saying in the market, like, that is, information is king. If you've got it, you know, you have an advantage and an edge. I mean, a lot of banks take that to another degree and have profit from information they shouldn't have or have shared with others. But you know, it's just literally that one DSAR to BBRS, and their response that was clearly wrong has just snowballed into something so much more significant. And how can they refuse? How could they have concealed their engagement with de Havilland, you know, and all the other stuff as well? So, I mean, I've challenged the Bennett, the lawyer for BBRS. Like, come on, then, sue me. You know, if you think I've made false and defamatory statements, then do it. And if he doesn't, he's got a major problem, because then, you know, you cannot make threats of action that you knew you had no grounds to make and you knew you couldn't carry out. And in his panic, that email to the ICO confirms that he was seeking to apply my allegations to the second DSAR response. So to appear that, you know, but not make that clear to me, but also he literally confirms that they should have provided all that information in the first one, confirming my position. So,
Paul, this is absolutely brilliant stuff. This is priceless intelligence for us campaigners and everyone else. Nigel Kane just put a note in the chat. Truly sinister. I think there is a really sinistery Orwellian dark side to this. I'm uncomfortable about it. We should at least ask some MPs to comment on whether they're happy to know that they're being surveilled.
Yeah, and fine. If you're selling my information, fine. I've got, okay, it's there in the public domain, but I want to know who you're selling it to, because they have, the people you're selling it to have to demonstrate that they're keeping your personal information for a legitimate purpose. And I am being denied that right by being denied, you know, the identity of the firms they're selling it to.
Thank you, Paul. Brilliant stuff. Paul, there's a question I've just put in the chat. It came up earlier. One of the attendees wanted to ask this question, but I think he or she wasn't wanting to disclose who they were, but it's a legitimate question. The question says, Paul, can you kindly ask Paul if you can make a DSAR to the FCA to obtain information held on you for, number one, a whistleblowing disclosure you made on financial and non-financial misconduct at a regulated firm, and two, information held about you regarding your FCA fit and proper status and submissions made against this.
Right. Well, the second one's quite straightforward. Yes, they have to disclose everything. When I did my DSAR to the FCA in 2017, they literally have to disclose everything to you regarding your status on the register. If you're not on the register, why? So that's absolutely disclosable. The first one is, well, I say it's a grey area because you often find with these areas that they should be fairly black and white, but the FCA or other organisations make them grey. And most people will have had a response from the FCA, we're going to apply an exemption, that to disclose that information would compromise the regulatory function or something along those lines. Therefore, we won't have to. To this day, the FCA has refused to disclose to me in response to DSARs any of the actions they did or didn't take in respect to Lloyds, in respect to the disclosures that I made. I have this year, though, found out, purely by chance, I've got an internal FCA document that they didn't disclose, that the PRA actually took regulatory action against Lloyds and the people about whom I'd made disclosures when I was at Lloyds. And that was withheld from me by not only Lloyds, but also for my tribunal, but also by the FCA. So, you know, it's just astonishing. But the fact that it was disclosed to me in response to a DSAR to another entity proves it should have been disclosed by the FCA.
Amazing. It's enlightening. Paul, I might end up trying to persuade you to do another one of these sessions, because a lot of people weren't able to join today, but would I know really benefit from this. We're going to go to Helen Scott next. Helen, please take yourself off mute and share your comment, question, point with Paul, please. And if you don't mind, Helen, just go straight to that. Share your thought. Thank you, Helen.
Hi, Paul. Brilliant presentation. You probably won't be surprised to hear that I have been embroiled in DSARs for the last couple of years with various organisations. I'm not talking about the FCA in this case, different organisations, more in my personal life than in business life. My problem has been, we get so far with the ICO, we get the ICO to say, yes, it's an incomplete DSAR response. The organisation has more work to do. They write to the organisation. I get back into dialogue with the organisation just as you've done. It goes on. And in the end, the organisation says, we've given you everything you're entitled to. Your DSAR is now complete. Go away. I go back to the ICO and say, this isn't the case. I've got circumstantial evidence, just as you said, that there must have been dialogue going on in the background. They haven't disclosed this, that and the other. And the ICO just says, we're under-resourced, we're not the police, we're not the courts, and we can't do any more. We have to just accept what the organisation says at face value. What do we do then?
This is a major issue. This is why I've been reaching out to people to, as you escalate to the ICO, even if you don't think so, because then we can all collectively establish that this is an industrial scale issue. This isn't unique. I mean, I hear, and it is like, someone comes to me the other week with I've just had this DSAR response from Barclays. They used my template and it was clearly the same. They'd just used exactly the same playbook, and it's everywhere I see people using the DSARs, they're getting the same thing. So we need to demonstrate to the ICO that this is a wide-scale, industrial-scale problem. Now, one thing that I've got, and I think the ICO has stepped up to the plate in the last year, certainly, more so than any other regulator I know, but they are drowning because of the widespread abuses. So, and I've seen correspondence from the ICO to the data controllers. We are not to be used as a dumping ground for your complaints. In other words, you need to start sorting yourself out. Well, clearly nobody is. And what's happening is, the ICO is drowning under this, so they can't then investigate, and because they've got all this queue of other complaints. So the ICO, I think, if we can establish, and we're working on ways we can do this, establish that these playbooks are industry wide, they are being abused. The abuses are therefore deliberate and premeditated. then I think the ICO has will have the ammunition it needs to really undertake some proper enforcement here. Just recently, they did issue notices and fines against a variety of government departments and even Kent Police as well. And don't get me started about Kent Police and their data law practices. But this is what we all need to do. And I think maybe we can start tying some of this together, Andy, and say, well, look, everyone's having the same communication here. The other issue is that the Fraud Act also contains a provision for fraud by failing to disclose information that they have a legal obligation to disclose. Well, the legal obligation is to respond to a DSAR lawfully. So if they don't, they're in breach of the Fraud Act. And I've made two reports to Action Fraud on that, and they've basically just closed it down without even looking at it. So when you've got another agency just passing the buck as well and not stepping up to the plate, it's all falling on the ICO shoulders. And
yeah,
I think they are trying to do the best job they can, but they are drowning because of the widespread abuse. But if we can show how widespread it is, and it is premeditated and pre-planned, and it's a playbook, it is a playbook, then hopefully we can get the ICO to do something.
Just to come back to you on that, Paul, I completely agree with you. The ICO, I do believe, are trying very hard. They are absolutely swamped. They're months and months and months behind, as you know. What they do is they eventually come back and say, we are not the police and we're not the courts, and you have the right to take this to court. But it's incredibly difficult to find out how you take it to court, and it would be very useful if the ICO could give some proper direction on that. It's impossible to know, for example, even what court form to use. The judicial service, generally judges are not familiar with GDPR. And it's incredibly difficult to find any judge that understands it. All that sort of thing, I think, if they are going to push it to the courts need to be able to deal with it, and people need to know how they can take it to the courts.
And this is another issue, Helen. Time and time again, I'm seeing every free process, and I mean free, that you should be able to avail yourself of, be it the FCA complaint scheme, your bank complaint scheme, all these other complaint schemes that are regulating that you have a right to, and even whistleblowing practices. I'm seeing these large data controllers and these regulators just literally seek to exhaust the free process, so that then you're left with no choice but to civil litigate. And everyone knows, that's £250,000 of your money. Who's got that? And that's a real worrying concern. And we've seen it. I've seen it with Lloyds this year. I've seen it with the FCA. My MP's on the case with that, and the complaint commissioner as well. I mean, it's and all of them then go, so if you want to take it further, you do so at your own cost and your own risk. So they are literally exhausting the free process that we should all have, so that you're left with no choice but to civil litigate. And who's got that money? You just simply, it just isn't possible anymore. I mean, I got a quote from a law firm about a year and a half ago to litigate on a £15,000 finance claim, 25 grand for them, and they would likely, the other side would likely instruct a QC, 50 grand. So your cost risk is like 75 grand to win 15. Like, it's just completely non-viable. And that's another issue that needs to be looked at. All these complaint processes and free processes are being abused, and and I think I mean, I saw that the FCA took an unregulated investment firm to court yesterday and got a decision in their favour. Shame they didn't do the same with Blackmore Bond, but with the ICO surely does have the powers to go to court and get some sort of order against one or more of these firms. It's unlawful.
It's a cracking point. It really is. Helen, thanks for raising that. Helen, would you be happy to maybe write a couple of paragraphs I could use as the basis of something to send to the ICO to say, given the idea that you're sending people to take legal action, could you provide some informational resource? And I'll liaise with Paul on the detail around it, but that would be a great idea, Helen. I'd be happy to do it.
And I think if anyone else has got any kind of experience of this kind of nature, or you're seeing the flags that I've been highlighting today, please do get in touch. And I mean, one thing we did after the Blackmore Bond presentation I did a couple of years ago, we reached out to anybody, and it was thanks to that response that we got all this new information and evidence that that then prompted what's gone on with Blackmore Bond since the Panorama program, and new stuff that, you know, let's just say there's some pretty punchy developments on that recently as well. So it shows that if we can just get people to share these experiences, they can't be ignored.
Yeah, can I just, it's okay if I just butt in there, guys. Mike Begg here from Beatty Banks. We've been doing fuel DSARs since 2011, and obviously principally against banks. And I mean, I have to say that I can tell you at one point, I think it was probably about 2015, Royal Bank suddenly exclaimed that they didn't have any data. And we reported it all to the FCA, you know, ICO, you know, and before that, they were getting all their data from Edinburgh. So Edinburgh were proper DSAR. Then after that, nothing, absolutely nothing. And we went to great lengths to show what was happening. So, for example, what the Royal Bank were also doing, if you had a joint personal loan, and there's PPI on it, and it's missold, the answer is because it's a joint and several liability, the compensation is shared between both parties. What actually the Royal Bank of Scotland were doing is, if it's hard data, and normally the second person on a personal loan, the Royal Bank of Scotland were actually not disclosing it at all. Not disclosing it at all. They were only disclosing the information to the first name party, and they're also only paying the compensation to the first name party. And again, we had long discussions with this. You know, I was at exec level with Megan Butler, had a conversation with her about it. Had to prepare loads of evidence, which we passed across the FCA. And guess what? Absolutely nothing happened. Yeah. Nothing. Right? In terms of, you know, what's going on now, you know, obviously it's pension claims we are doing. The financial companies, when you ask them for information, one that we've highlighted today to Citywire, had a long conversation with Citywire earlier on today, is Portal Investments, Portofino Investments, LLP. You ask for the customer's data, they give you this one-page summary, which you referred to earlier on, date of birth, name, blah, 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 nothing else. These are all the reasons why we don't have to present that. We then take the case to the ICO. Eventually, I think it must be in one guy, but a year later, we've eventually got his file back. Obviously, we didn't get the phone calls. I phoned them on Friday, their solicitor, to say, look, just to let you know, I'm going to be speaking to Citywire on Tuesday. And, you know, I've obviously been mentioning the fact that you've not sent me the phone calls yet. And remarkably, they all arrived yesterday and today. Incredible. But this is what they do. And we've reported this all to the FCA as well. They're saying, look, guys, you know, what's going on? So, for example, for Portal, have a previous firm, which is Portal Investments, LLP. That firm's, you know, got something like 150, 160 ombudsman decisions against them. And again, you know, shared directors, they've kind of morphed from one firm to another firm. The old firm don't give you any data either. Just reply to nothing. Blank you completely. It's just.
Thank you for sharing that. Thank you very much indeed. We're going to get one or two other questions about DSAR squeezed in before Paul goes on to talk about freedom of information requests. So I'm going to go to gallery view so I can see all of you in little pictures.
I would just say that again, it's what you're describing there is exactly what we're seeing time and time again, and from, you know, pretty much every data controller.
Yeah, wave a hand or something at me, digitally or otherwise, if you want to come in with a comment or question for Paul. Otherwise, we'll move straight on to. Can I just
come in with just another thing here about data protection? So we had a very big business that went bust in Scotland called the Independent Benefit Consultancy. So there's lots of defined benefit final salary pension transfers. And what's happened is clearly data has been sold to a firm called Simon Adams Solicitors, who we've had a number of customers, and they've actually cold called them to death to say, look, guys, you have a claim here. Customers have said, well, I don't have any data. And they said, no, it's okay, guys, don't worry. We've got all your information here anyway, right? So I've reported it all to the FSCS. You know, they just use, oh, yeah, you know what, we'll take note of that, blah, 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 blah. But the problem is there's no sharing of information between the FSCS, the ICO, and, for example, the SRA and the FCA. None of them seem to want to share information between one another. Whereas if that was done, problems that are there could be addressed much more quickly. But there seems to be
I know
complete unwillingness to do anything about this.
We understand that. That's an issue that we see in many, many different ways. Thank you for your point. Paul, there's a couple of questions that have come in from an individual. Can you put it? I'll put them in the chat. if you do get the chance, this person would like to ask below. Number one, is a settlement agreement that prevents you requesting a DSAR in its text enforceable under the law? And number two, are you able to make a DSAR if the company says the information is subject to legal privilege, even if there's no legal case happening? Paul.
Okay, some of this strays into a legal advice area, so I'll just explain what my understanding is of this, but please understand this does not constitute legal advice. A settlement agreement that prevents you requesting a DSAR, right? Now, I've got one of these. I've actually got a settlement agreement with a firm that paid me a substantial sum, but only on the basis, because I'd made a complaint. They had basically lied their backsides off. I then submitted a DSAR, and then I got a substantial settlement on the basis, but I had to withdraw my DSAR. You know, quite clearly, because they had something to hide, and I was on the money. They had clearly lied in their complaint response. A female colleague, a former female colleague of mine, had made disclosures about discrimination of pay at a major bank, and within 3 months she was being made redundant. And she was the lowest paid by far, but she was the biggest earner on the desk. And so I said, well, here we go, DSAR. So she used my template, hit them with a DSAR, because they were offering her like 40 grand redundancy, which relative to pay, you know, was, you know, best part of 150, 200 grand a year was peanuts. They withdrew the first agreement and then came back with the second one, offering the same 40 grand, but now she was only getting it if she withdrew the DSAR request. So we took that to a lawyer and said that is an absolute disgrace, that you cannot do that. And then basically within 2 weeks, they provided a new offer. They still kept the clause in there about you had to withdraw the DSAR, but this time it was with a 400 grand proposal for settlement. So again, they clearly knew they had something to hide. She wasn't threatening litigation, she just did a DSAR, and then all of a sudden they found themselves in a hole. Now, I had this discussion with my own barrister a few weeks ago, and it's an interesting dilemma. You know, did you have legal advice prior to agreeing to it? But yeah, it's one that if you've accepted a settlement that you were happy with, or did you provide it under duress? I think those are considerations, but I would, with that, definitely seek some kind of independent legal advice before you do anything, 100%. The second question, are you able to make a DSAR if the company says the information is subject to legal privilege? Now, this is really interesting because I've been helping somebody that was subject to a libel related issue, should we say. It's not Tom, it's Tom Hayes, somebody else. They issued a DSAR to their employer, who initially wrote back and said, we're going to need the extra 2 months they're allowed to ask for by law if it's turning into a substantial disclosure. And they said, there's so much information that we need the extra 2 months. 2 months later, they wrote back and said, no, we're applying privilege to everything, you're not entitled to anything, and literally gave him nothing. Now, the issue here is that and this is a really interesting argument. It appears that the bank has sought to apply privilege to documents that weren't previously subject to privilege, but because the bank was assisting in a prosecution, they've then sought to apply it. That is a really interesting case, and as I understand it, there are serious concerns when somebody tries to do that, because you can't otherwise. What's to stop you? Right, okay, this instruct external law firms, therefore we can put a blanket privilege over everything and therefore circumvent law. So I think there's definitely some opportunities there. And also legal privilege, it's an interesting one. It only applies if the relationship between the parties that they're claiming privilege exists between is if it was being done for the provision of legal advice. Now, I did DSARs, as Andy knows, to Ashursts and to Monkton Chambers, the two firms that provided the support team to John Swift KC. Ashurst provided a response to my DSAR, and it's a shocker for them. It's not complete either. So, but Monkton's tried to apply a legal privilege to everything. Well, hang on, you were instructed the same as Ashurst were they didn't seek to apply that legal privilege exemption. And furthermore, and this is a really interesting case because there's an employment tribunal case. It was a UBS employee had made allegations of being raped by a former colleague, and Freshfields, the law firm, were instructed to investigate, and UBS sought to apply legal privilege to that investigation. And the judge at the employment tribunal ruled that no, you clearly established this was an independent investigation, therefore not the provision of legal advice, so therefore you can't apply a privilege, which I argue is the same exists in terms of the Swift report. It was an independent investigation, it wasn't done for the provision of legal advice. So I'm challenging Monckton's on that. So the legal privilege one is a real issue, and if somebody is seeking to apply legal privilege, I would definitely take that up with the ICO, especially if it's documents that clearly would not otherwise have been privileged, as per this guy's case. The legal actions commenced in 2015, I think, and they're applying legal privilege to documents dating back to when they started at the bank in 2006. That cannot be the case.
There's really good quality questions going on here. Paul, would you be happy if when Chelsea sends the notes out about this meeting tomorrow with all the chat and so on, if people wanted to get a question to you, are you okay for me to kind of capture them all, get them across to you so you can deal with them, if that's okay?
Yeah, of course. And I think I won't give, it won't be legal advice. It's literally just, this is what the law says, and this is what I found. So
yeah, no, that would be very, very helpful to many people, I know. And I know I'm repeating myself, Paul, but I might end up having to ask you really nicely to do another session like this because so many people wanted to come today, but they couldn't make this particular time. Thanks, Paul. We're going to ask Paul now to move on to the topic of freedom of information requests. Paul indicated earlier it's a lot more straightforward. Paul, back to you.
Okay, so data laws also enable you to submit freedom of information requests to typically government departments, political bodies, or regulators like the FCA, the SRA, you name it, but it's got to be an official kind of capacity. So you wouldn't be able to do a freedom of information request, for example, to Lloyd's. You know, it just wouldn't apply. That's the DSAR. The freedom of information request is simple, and you can ask them quite reasonably for anything. You know, they don't have to apply it, but or provide a response to it, but they have to provide you information. One that we used very effectively with regard to Blackmore Bond, we submitted a DSAR to Action Fraud and City of London Police and asked for, can you please provide a how many reports you received about Blackmore Bond between 2016 and 2020? Can you give a breakdown by year? And can you confirm whether or not the FCA was one of those parties that made a report? And they had to come back and they gave us a table showing that there were 71 reports, one of which was in 2016, the year it was launched, and between 2016 and 2020. And they confirmed that the FCA was not at no time made a report to the City of London Police about Blackmore Bond. So that was incredibly powerful, and that was used in the Telegraph article, and obviously has been expanded upon since to feature in the BBC Panorama. So that's the kind of thing that you can request. I've done similar requests to the SRA. Can you please provide complaint statistics over the last 5 years? And they'll show the number of complaints and the numbers upheld, numbers not investigated was an interesting one, but they have to disclose this kind of stuff. Now, the FCA is under the same obligation. So, but there are exemptions. So, for example, the party that you're submitting your request to is not obliged by law to spend, don't quote me unless I think this is the right amount, is not obliged to spend more than £450 in the process of responding to your request for information. So you think you have to be careful about framing that. Okay, make it as simple for them to provide a response to as possible. In the FCA's case, they will find a way to misinterpret it, to overcomplicate it so that it does get drawn out. And the other exemption they can apply is that if your request is vexatious. Now, vexatious is something that is, it's motivated by other reasons. It's malicious or is designed simply to waste time. Now, what we've seen recently is that I don't know if you watched, if you're familiar with the FCA annual public meeting, Mark Stewart made multiple representations at that meeting, 6 of them specifically in respect to Blackmore bond, that clearly unbeknownst to him, I could prove were false and or misleading. So in the days following the FCA APM, I issued 6 separate freedom of information requests, and each one was specific to a representation or statement that Stewart had made. I copied the Treasury Select Committee on it for reasons that will become clear later. And I highlighted I've got a transcript of his testimony. I highlighted the phrase that he used, and then I provided attached to it all of the evidence to prove that that was a false or misleading representation, and then followed it by questions to the FCA saying, please provide information to explain how Mr. Stewart came to make this representation that he either knew was false or should have known was false. And so I did that in respect to 6, and all of it supported by evidence. And literally yesterday, the FCA came back late yesterday and replied, and they put all of them that I've made over several days into one response and said, we're not going to provide any of the information on the basis that we consider them to be vexatious. Now, every one of them was supported by evidence that, no, he lied. He made a false representation. And I'll give you an example. Mark Stewart said that everything in the Blackmore bond marketing material was fair, clear and not misleading, and contained adequate risk warnings to potential investors. And so therefore we do not believe there's anything wrong with that material that was signed off by an FCA regulated firm called NCM. I've got a copy of that 2018 marketing brochure, and in it, right, first of all, in terms of the risk warnings, it on 13 different occasions, it says your investment is guaranteed. There is a section that is devoted to risks, and it's 3 or 4 pages, and it highlights the various risks that might occur and that you might lose your money. However, then at the end of that section, it says, however, in light of these risks, we have obtained a capital guarantee scheme so that if any of these risks occur, this kicks in, you get your money back. So yet Mark Stewart had said that this document contained absolute, appropriate risk warnings, when in actual fact, this document said that this was essentially a risk-free investment. The other thing that he said was that everything in there was fair, clear and not misleading. However, there is a page in there that is devoted to their track record. And it says, in the past 2 years, we have completed 16 projects that have gone to sale and generated 28 million in sales, each of which has generated an average of 20% profit for Blackmore bond. Well, it took me 5 hours to discover that none of them were Blackmore bond projects. They had nothing to do with Blackmore bond. And yet it was that track record that was in that document, had been signed off by an FCA regulated firm, that was being used to induce investors. And that Mark Stewart at the APM said that material was fair, clear and not misleading. And yet the firm and Blackmore bond had lied their asses off. I'm sorry for the French, but that was clearly a false representation. So either Stewart knew that was false, or they hadn't done the appropriate investigation of it. So how the FCA can come back and say that my requests were vexatious, they were all specific to something the FCA had said. I included all the evidence to prove that that was false and or misleading. How's that's not vexatious. That is me holding a regulatory body or a public body to account. That's the whole purpose of the Rights for Freedom of Information Act. That is, you are entitled to do that. Otherwise, they can just lie their backsides off. Now, so I'm going to be taking that further. But that is not the only one. I received, days before the FCA APM, I received responses to, I think it was about 15 different freedom of information requests that I'd submitted in the preceding 3 to 12 months. And they just bracketed them under 5 different headings and went, bang, we're not providing a response to that because we've now deemed them all vexatious. So yeah, we're not going to provide the information. And yet none of them can be considered vexatious. They are all relevant to statements of fact or records that the FCA has produced. And I'm seeking to challenge that. And I'm doing so with evidence to prove that, well, hang on, that's not correct. And last week and I've maintained that Mark Stewart stepping down from the FCA has to have something to do with the multiple false or misleading representations he made at the APM, and he also made in a Sunday Times interview following the Panorama broadcast. And also there was a I've challenged him over one of the things I challenged them over was that in the broadcast Panorama, the FCA said, we didn't do nothing. In 2017, we shared information with City of London Police. Okay, what did you share then? Because I've got a letter from the FCA confirming in writing to me that they were contacted by a law enforcement agency in 2017. However, due to human error, they shared none of my intelligence or information, and none of that gathered by others with that law enforcement agency. So what did you tell the City of London Police? To claim that you shared information with them when you didn't share any of the key intelligence is misleading and disingenuous at best. And last week, before the Treasury Select Committee, Richard Lloyd was asked specifically, he's the current chair of the FCA. He was asked, does Mr. Stewart stepping down have anything to do with Blackmore Bond? Mr. Lloyd said no. He didn't elaborate. But my follow-up question to that be, well, if not, why not? The Treasury Select Committee gave them all them. I know they probably didn't have a chance to digest them fully before the meeting, but he made representations that were false and or misleading. So if he wasn't forced to step down because of that, why not? And there was another question that was asked as well by a Treasury Select Committee member, Mr. Lloyd, and they said, is it true that the FCA put in writing that they missed an opportunity to act on the intelligence of somebody that was provided by somebody? Lloyd just dodged it. And the Treasury Select Committee member is referring to the letter that I got from the FCA clearly by mistake. And it was the letter produced by the person that spent a year investigating my allegations that they hadn't investigated Blackmore Bond. And in that letter, it was never sent to me. It was dated a year earlier, but whoever in the data team sent it to me clearly thought it had been sent because it said sent to Paul Carlier. So again, they thought they were sending me something from the scene file when it wasn't. And it was the draft response where this guy concluded, not once, but twice, in respect to my reports in March 17 and in respect to my reports in August 18, that we missed an opportunity to act on your intelligence. However, immediately he produced that, he'd been on the case for a year, he's taken off of the case, they're crossed out, and they left the track changes on to show that they were crossed out. And then the person who replaced him spends another year looking at it and produces a complaint response that has all of that taken out of it. But that guy was investigating it. That's what they concluded. The MP on the Treasury Select Committee asked the question and Lloyd just didn't answer it. And I've written to the Treasury Select Committee and said, here's the answer to your question, there's the letter. But Nikhil Rathi said something, he interjected at one point last week. And again, this is all relevant to these freedom of information requests, one of which was, how is it that the FCA, Mark Stewart, said that the Insolvency Service has investigated Blackmore Bond thoroughly and had decided there was no wrongdoing by directors or the business, and therefore they were taking no action. So I wrote and challenged that. I said, well, how can that be? Because I've got evidence to show that Blackmore Bond was in no small part of a Ponzi scheme, and I've got the evidence to prove it. There was two investors that I got in touch with me after the Transparency Task Force presentation that confirmed to me they never invested in Blackmore Bond. They invested in something called Blackmore Estates beforehand. It was another Nunn and McCreish vehicle. And when that matured, they presented Blackmore Bond as a Carlos Fandango all-improved investment and offered to transfer their original investment plus the returns they generated on that investment into Blackmore Bond. I helped these people behind the scenes, and one of them was John Robbins, the Army veteran who featured in the Panorama broadcast. And I helped them frame their request to liquidators and said, can you confirm that an investment was made in my name into Blackmore Bond on or around the estates? The liquidators wrote back saying, yes, we can confirm that company records show that investment was made in your name for that amount. In other words, the amount they invested plus the interest that they'd been told they'd accrued on or around that date. I then drafted the follow-up, say, okay, please provide evidence to prove that there was a transfer of cash or equivalent value asset from Blackmore Estates into Blackmore Bond on or around those dates that represents the transfer of that investment. It took weeks and they didn't want to reply. And in the end, I had to ask the two investors to give the authority for me to write and get the information. And the liquidators had to confirm that, yeah, there was no transfer of cash or asset to equivalent value to Blackmore Bond on or around those dates. So that's, to me, that's a Ponzi scheme. And there was the company records needs to show that there's things. You need to keep that running, but there was no cash transfer, cash or assets. And liquidator said that they had raised concerns on this with the insolvency service within the first 3 months, as they're bound to do by law. So how does the insolvency service square that? And I've now got data as well to show that when the liquidators went in, they did a current valuation of the entire portfolio of assets owned by Blackmore Bond, 20 million in total. However, against that, there was lending of 18 million secured against that. So where did the 48 million go?
Thanks, Paul.
So,
Paul, your insights are just amazing. They just really are amazing.
Just to finish on one thing, Nikhil Rathi interjected with Richard Lloyd, said to the MP at the Treasury Select Committee, yeah, I should point out that the FCA, the Insolvency Service, did a thorough investigation and concluded that no action would be taken. Well, that's neat wordplay, but it doesn't say they found no evidence of fraud or wrongdoing, just that they're taking no action. You know, that is disingenuous at best, because he knows that you're going to take from that oh, they must have found no evidence of wrongdoing. Whereas if the question had been, did you, the FCA and the Insolvency Service, find any evidence of the Blackmore Bond being a Ponzi scheme, he'd have had to answer, yes, we did, because I gave them the evidence. So remarkable.
I'm going to be showing a very short video clip in a moment. The reason I'm going to be showing is because please remember, everybody, that what Paul's been talking about today is symptomatic of a really, really sick system. Without getting too melodramatic about it, Roger Mullin, a former SNP MP, spoke at one of our events about a month or 6 weeks ago, and he spoke about state capture. He spoke about state capture in the context of a report that he produced about corruption in the UK. And in all honesty, for years and years and years and years and years, I perhaps quite naively thought that our country is free of all that kind of stuff. Corruption is something that happens in other countries, not the UK. I was just brought up in that way, that the UK, doesn't behave like that. But increasingly, what we are seeing with our own eyes is more and more evidence of not just parts of the system being sick, but it's all sick. There are some widespread ecosystemic problems. It's as if there's a contamination of corruption that's been going around, and it's really difficult to say this kind of stuff without sounding like some conspiracy theorist nut job. At 9:30 last night, I received a phone call from somebody TTF really admires, Lord Prem Seeker, about a short speech he'd given, a question, in fact, in the House earlier in the day. I'm going to play it to you. I absolutely think that what you're about to hear from Prem is 100% correct. Listen to what Prem says, and listen to the kind of overly confident, flippant, dismissive, frankly disrespectful response he gets from somebody. Let me share my screen. Share screen, share sound. Here it is. Share, 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 share. I'll try to make this as big as I can. Please listen attentively to what Prem says. This is Lord Prem Seeker and the response that he gets. And by the way, I'm not making a party political point. I really am not. But listen attentively to this. And by the way, if you don't know Lord Prem Seeker, he has a very, very strong subject matter expertise background. He really does know what he's talking about.
Businesses associated with the City of London gave us the last financial crash and have also been routinely involved with the mis-selling of numerous financial products. They've been involved in money laundering, tax abuses, frauds, forgery of customers' signatures, and numerous predatory practices. Could the Minister explain when the government will launch a public inquiry into the city's predatory practices and clean up this industry?
Well, the noble lord is wrong, as he is on so many of these matters. Of course, proper regulation is important, and in fact, we will shortly be considering the Economic Crime Bill in order to clamp down on many of these practices. What the Noble Lord forgets is that the City of London is one of the most successful financial centres in the world. It contributes billions of pounds to the British economy. He's always calling for more public expenditure. If he kills the City of London, he'll have even less to spend.
Businesses associated with the
So this is what we're up against. We've got intelligent people with evidence and insight and experience like Lord Prem Seeker flagging the fact we've got major systemic issues, asking intelligent, relevant, worthwhile questions, and he gets a response as lightweight as that. That is what we're up against, people. That is what we're up against, people. His question was not responded to. The question response should have been, if you as a Lord are that concerned about this issue, then you know what, we should maybe talk to you and find out what your particular issues are and get underneath the bottom of it. And yes, you know, we recognise our country's got a reputation on the global stage as being a major centre of illicit money flows. It's just truly shocking. Mr. Carlier, your hand.
Yeah, I mean, last week you had Nikhil Rathi and Richard Lloyd demanding that you know, that the FCA has to remain independent because it's so important, that the integrity of the UK financial services is so important to the UK. Well, the integrity of it is reliant upon it being all open and above board. So you've got the FCA effectively saying, yeah, there should be inquiries to make sure that it is honest and there is integrity there. And yet you've got that response by a government minister that's just dismissive, you know. And how much would, and let's just look at that as well, okay, how much the city generates. The amount of money generated by the banks from mis-selling IRHPs was substantial amount. However, it pales into significance to the amount it cost those that were affected by it. Thousands of businesses destroyed, multiple thousands of jobs lost, people committed suicide, and the billions that were lost from disposable income. And you want to know why there was no growth over a decade? You think we're talking 20 to 30 billion potentially just from the businesses that were excluded from the IRHP review. They're the direct and consequential damages, but that doesn't show the damages to the employees of the firms that got laid off. You know, the supply chain damages as well, when these businesses went under and couldn't pay their suppliers and affecting that. So the damage to disposable income in the UK, which drives spending, which drives consumption, which drives demand and drives a successful economy, is entirely being compromised by wrongdoing, but by banks where they're making a fraction of the actual damage being done. So in response to his position, there would be a far healthier economy and far more disposable income available, but for the wrongdoing in the first place. By the
Absolutely. System. Absolutely. Very, 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 very well said, Paul. Very, very well said, Paul. We're going to bring things to a close. I'm going to ask Paul very nicely if you'd be happy to run another session a lot like this one in the future, because what you've shared, Paul, has been very, very valuable to me and to many, many other people. We do need to bring it to a close, but it's been a great session, particularly good, Paul. Can we once again, please, all show our appreciation to Mr. Paul Carlier, who shared all this knowledge and experience without any fee at all. It's been entirely free. And it's been remarkably beneficial. Thank you very much indeed.
And
Paul,
just one thing, I've put a link.
Last words to you. Go on, sir. Go on. Yeah, thank you.
I've put a link in the chat, and it's I've put a page on my blog where it's the resources. So on that page, you've got my DSAR template, and you've got other really helpful resources, so that download it and you amend it to your needs and submit it and use as freely as you want.
Absolutely fantastic, Paul. Thank you very, very much indeed. There are some lovely comments coming to the chat here, Paul. Excellent session, Paul. Thank you. Look forward to part 2 from Sarah. Julie P says, thank you, Andy and Paul. So informative. Very much appreciated. There are many, many others like it. Amazing session. Thank you so much, Paul, from Sashi. Huge standing ovation for Paul in brackets. You deserve it, Paul. You really do. For some of you just won't realise how much time Paul and others are putting in behind the scenes to try to drag the truth to the surface. You know, the phrase we use quite a bit, sunlight is the best disinfectant. Paul's a shining star in that regard, and many, many others. Paul, you said something in one of our Transparency Times is, we put it as a thought for the week. I think it was this, something like this, Paul, correct me if I get it wrong. 2 most important rules in life. Number 1, don't give up. And number 2, don't forget rule number 1. You are a remarkably tenacious and determined person, and I know why and how, and you're remarkably effective. Thanks again, Paul. Well done. Well done, everybody, for turning up. Cheers. Thanks, guys. See you next time. Bye-bye. 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 Thank you.